Hey, John Henderson here with HH Law. I'm joined today with Price Sigal. She is a criminal defense lawyer, worked at the prosecutor's office over a decade, and now she's doing criminal defense. She is going to help us answer one very big question. How does law enforcement prove a DUI? Price, thanks for joining us.
My pleasure.
All right. The overarching question, we're going to get into the breath test in a minute. We're going to get into field sobriety test in a minute. But before you are pulled over, what is law enforcement getting? What kind of evidence are they collecting if they suspect you've been drinking?
Well, their patrol car is equipped with a video that it's basically always running. And if they decide they see you swerving, they're going to turn their lights and siren on, and the video basically predates that moment where they turn on the lights and siren. So you're driving, and any mishaps you have driving are caught on video. That's number one. And that's the first thing they'll use to say, well, that's why I pulled you over. And it's basically their ability to then ask you more questions about your night. So that's step number one. The second thing is they're usually going to ask you to get out of the car, which I always say do. You don't want to get argumentative with the officer, even if they're not being nice. You still want to be nice on your end. All of this is being recorded. They wear body-worn cameras, and it's usually just right there on your face. And so if you're acting like a jerk, even if the officer is, if you are, it's right there for a potential jury to see.
And just one question on that. So you're pulled over. You obviously want to be polite and forthcoming when law enforcement pull you over. But also their right or their ability to get you to come out of the car is based on their safety, right? So they could always cite that I had safety concerns.
Always.
I just wanted them out of the car.
Always.
But there's a secondary thing to that, right?
Yeah, and when you get out of the car, obviously, don't make any big movements that would scare the officer. You just want to get out of the car and be as mild-mannered as you can. And usually then the officer would start asking questions. What have you been doing tonight? Have you had anything to drink? And kind of goes along those lines of questioning. And often I say, you can always invoke your right to an attorney immediately. They usually don't read you your Miranda until later in the stop when they're about to arrest you for DUI, but it doesn't mean you can't invoke those rights right off the bat if you think you need to.
Absolutely. And so people should know, and everybody should remember that you have several rights with every stop. You got a Fourth Amendment right against unlawful search and seizure, so they can't search your car without a warrant or probable cause. You got a Fifth Amendment right not to give a statement, and then you have a Sixth Amendment right to a lawyer. So in every instance, you've got those. Okay, so even before you do a breath test, even before you do any of this stuff, they're collecting information. They're able to get you to get out of the car, see if maybe you wobble, something like that. Right.
From the moment they turn on that camera, they are looking for evidence. And even if they are as nice as they can be, they're evaluating you and your demeanor and whether or not they think they can arrest you. And so you should never forget that. Even if they say, I want to help you out and offer to let you do field sobriety tests to show how sober you are, they're not doing it to help you. They're doing it to see if they can collect evidence. So everything that you say and everything that you do, keep in mind that is evidence against you.
So let's look at this context. Okay, so blue lights, I'm pulled over. Law enforcement has me crossing the center line just once, maybe. Okay, they've got that on video. Then they ask me to get out of the car. I'm a little clumsy. Maybe I'm not stumbling, but I'm a little clumsy getting out. Then they cite that they can smell alcohol. Am I done for?
You could very well be arrested just on that.
Yeah.
So they have the ability, really they just need probable cause for the arrest. It's a very low bar. It's very different than the standard that you would need to be convicted of the charge. Probable cause just means it's likely that you were driving under the influence. It's a very low bar. So yes, those few things, if the officer says they smelled of alcohol, they went over the line, and they wobbled, that's enough for them to be able to arrest you. However, they're not going to stop there. They're going to ask you to do field sobriety tests. And
Is that next or the breath test?
That's next.
Okay.
So, usually, and usually the field sobriety test, that includes the walk and turn, where they ask you to take 10 spaces, 1 foot in front of the other, and then turn on your left foot and come right back. And sometimes it can be very complicated directions. Again, they're looking to see if you trip up. They're not trying to help. Same thing with the one leg stand, and sometimes they make you raise a leg. And there was also a test called the horizontal nystagmus test, which is to gauge your ability to follow something with your eyes, with a light. So all of those things, again, that's evidence against you. That is padding their file. Even if you think you do pretty well on it, they're going to try to say, oh, they kind of count on their report how many violations you may have during those tests. And I've seen just the slightest wobble as count as a violation. And then their report looks like you've failed it.
Right.
So the good news is with this, you don't have to do the field sobriety test. You can actually decline them. Most people don't know that. If they get through the field sobriety test, regardless of how it goes, if it goes poorly or it goes well, they're likely going to also ask you to do a breathalyzer test. That's what most people think of when they think of DUI. The legal limit is 0.08, which means that gives the presumption that you've been driving under the influence. However, you can also decline the breathalyzer. The officer's going to be quick to tell you in South Carolina that refusing the breathalyzer equals an automatic suspension of your license. And that is true. You will wake up the next morning without the ability to drive. However, if you get an attorney, they can tell you pretty quickly you can get a temporary alcohol license. And that is a process that a good DUI lawyer should know and be able to implement pretty quickly. And sometimes you can get a temporary license within a week. So don't let the fact that you might lose your license for a few days scare you into giving a breathalyzer if you don't want to give a breathalyzer. That can be handled. And the officer's not going to tell you about a temporary alcohol license. They're just going to say, you're going to lose your license for a year. So just know going into that actually there is a way out of that.
Okay. That feels like that's putting them in a power position, obviously. So you're now in a position to give over evidence. Tell me if you think that this is true or not. A mutual friend of ours has prosecuted lots and lots of DUIs, basically told me about 10 years ago, he's like, if you get pulled over at night and you've been drinking, you're going to jail. You think that's probably a fair assessment?
Yes, I think that if you're driving at night and the officer thinks that you've been drinking, you're going to jail because the bar is very low for an arrest.
And they've got some evidence.
If the officer thinks that at all, it doesn't matter what you refuse to do. If they see you swerve and they think, I bet that guy's drinking, then everything you could do in their mind could be indicative of drinking.
Because of a psychological thing we all do, confirmation bias.
Right.
Once we have a conclusion, we are finding evidence to fill it in, right?
Exactly. And so, for example, your refusal to do a field sobriety test, the officer may think, of course, they're not doing it because they're drunk. Same thing with the breathalyzer.
Sure.
However, just because the officer thinks you've been drinking and just because you may get arrested and spend a night in jail, which I'm not minimizing, that is not what anyone wants to do, it does not mean you'll be convicted down the road. Those are all small pieces of evidence, and the bar to be convicted is so much higher, thankfully, that just these small circumstantial evidence usually is not enough unless you appear very drunk on the video.
Right.
Yeah.
So the things that you can do are polite to an officer, try to minimize the amount of information or evidence that you're helping them collect. What can lawyers do to help clients in these circumstances?
Well, the first thing is if your client does refuse to blow and lose your license, the first thing is you're going to want to get that notice of suspension that your client was given at the time, and you're going to want to submit that to the DMV to ask for an implied consent hearing, which would be scheduled down the road to basically contest the license violation. The minute that's scheduled, your client can then go apply for a temporary alcohol license at the local DMV. So let's say that you get notification within 3 days that the hearing is in 2 months. Within those 3 days, you can then get the temporary alcohol license. So that's what a lawyer should do immediately to get your client back with their license so that they can work and tend to their family and everything else they need to do, which is usually everyone's first concern, actually.
Right. Yeah.
Usually with a DUI first, your court date's within the next 30 days, so you want to look at that court date, and you want to make sure you have that on your calendar. You want to obviously get the evidence against your client. Mm-hmm. Sometimes if it takes a few weeks to get the evidence, you're going to continue that first court date, so you can look at everything. And then the things you're going to look for as an attorney is, did the officer do the Miranda appropriately? Was it caught on video, which is required in DUI law? With the breathalyzer, did the officer follow every single step? Because officers are really, their feet are held to the fire with DUI. If they do not do things appropriately, they can really affect the case and get it thrown out. It's different from other criminal laws. So DUI is its own thing with officer regulations. So most attorneys want to look to see if the officer did everything right. If the officer did everything right, which like a state trooper, they're going to do everything right. So it kind of depends on the agency too. Then you're going to want to obviously watch the videos. How does your client look? If your client looks drunk, Okay, that's a different thing. Now we're not so much in the arguing against the legal aspect, but the mitigation. Does your client have a clean record? Have they made major life changes since this happened? The officers, what they're usually focused on is this person going to continue to be a danger to the community?
Sure.
Are they going to be out drinking and driving and going to kill someone? If you have a client who really was thrown by this whole experience, get them into classes, get them into, alcohol classes, mothers to get drunk driving, take one of those classes. And then when you go to the prosecutor and you say, my client's already done all these things without being asked because they actually are so upset this happened. Well, then that prosecutor knows, okay, and the officer knows, maybe they won't be a danger to the community if I cut this guy a break. So those are the things, first up, you want to get your client thinking about is mitigation.
And we've seen this a lot where law enforcement writes up the report, looks like person's drunk, but then in the videos, it's like, I don't know if I can really tell. So even if they do the field sobriety in some of the activity, maybe law enforcement is writing it up like they're drunk, but maybe it doesn't look like that.
Exactly. You could have a situation where, you have the one leg stand and you tilt a little bit, but the officer says you wobbled and it was very obvious that you wobbled and, you failed that test. Whereas you watch the video, you think person actually did pretty well.
Right.
So the report is not always the end all be all. And the jury's not going to see the report. The jury is not going to see the police report. They're going to see the video. So any good lawyer is going to watch the video and evaluate it based on what the jury's going to see, because the jury is not going to see that report. Okay. So if the officer wrote an incredibly biased report, the good news is the jury's not going to see that. They're going to see the actual evidence.
Right, because the officer is judging subjectively. These aren't objective tests, the field sobriety ones.
Right.
Yeah.
Exactly. It's different from the breathalyzer that gives you a number.
As an objective.
And it should be noted that, there are a lot of studies about the breathalyzer where it's not exactly accepted as absolute truth. Sometimes these machines have different issues. And any good lawyer would present all of that at trial to show, just because you blew something, it actually, they're just like any machine or computer, there are issues with it. And, those are all being, studies are being done all the time to try to make sure law enforcement is using the most up-to-date technology, but it's technology.
Right. Price, thank you very much. This is John Henderson with Price Sigal. We've been talking about DUI laws. We do encourage you, if you are outside of the state of South Carolina, to keep in mind that these are South Carolina specific situations and laws. Consult a lawyer in your local jurisdiction for more information. And if you are in South Carolina, you need our help, please give us a call. These are all fact-specific scenarios. So be sure to give us a call. We're happy to help. John Henderson, thanks for watching.